Welcome to Ask a Lawyer with attorney Joey Franks at the Franks Law Firm in Ridgeland, Mississippi. Each week, Joey answers your questions about the law and how it affects you.
Joey, what are the DUI defenses?
There are a myriad of defenses in a DUI case. They range from procedural to legal to factual. And when I say procedural, one of the big things is an officer has to have a reason to stop you, and it's called probable cause or reasonable suspicion. If they cannot show that and they didn't have any reason to stop you, then the rest of it doesn't matter. They didn't have the right to stop you, therefore all the facts they have is considered fruit of the poisonous tree and cannot be brought in a case against you. And quite often we get cases dismissed based on lack of reasonable suspicion or probable cause. And then we get into the legal issues. Well, did you blow .08 or not? Because if you didn't, then you didn't meet the statutory requirement. Then they have to go and look at common law DUI. And that's where the facts of the case come in. The field sobriety test, the walk and turn test that you always hear about, the stand on one leg and count to 10, the horizontal gaze and nystagmus test that we talked about in a previous episode. All those are factual things that they are looking at to show impairment. And sometimes they skip steps. Officers are human beings. They skip steps. Sometimes machinery breaks because that's what equipment does. And sometimes so much time passes that people forget things. And all that goes into building a defense for a DUI case. There's no one thing that we look at as a DUI attorney. We love it when we see the nuclear bomb defense sitting there, but that's usually not the case. We usually have to nibble and bite at it in bigger chunks and eventually wear down the prosecution's case.
Let's say I've been drinking and I'm driving and I see a checkpoint. What do I do?
Well, there's really no great answer for this, because what's going to happen is they have likely set the checkpoint up in a position to where by the time you see it, you cannot turn off the road without it being suspicious. And an officer will say that was his reasonable suspicion and come pull you over and talk to you for a little while. If you can turn off on some side road or you can pull into an apartment complex, by all means, that's something I would seriously consider doing if I personally was in that situation. Alternatively, if you must go through the checkpoint, have your ducks in a row. Don't make the officer ask you for a license, registration, and proof of insurance. Have it in your hand when you pull up and just roll the window down just enough to pass the information through, because you don't want him having his head stuck off in your vehicle trying to smell for alcohol or marijuana or anything like that. You don't want to sit there and for an extended period of time while he can observe bloodshot eyes or anything, and you want to say as little as possible. If he says good afternoon and you can just get away with nodding, because then suddenly he can't talk about slurred speech. So there are steps that you can take to certainly minimize your exposure and your contact with an officer, and I highly recommend that individuals do that. Even if you have not been drinking, you never know when somebody has left something in a vehicle that an officer is going to shine his light on and start asking questions about.
Yeah, good advice. Is a DUI, is it a felony or a misdemeanor?
It depends on the circumstances of the DUI. Generally, a DUI first and a DUI second are misdemeanors. And what that means in Mississippi is in misdemeanor is anything that requires less than a year of jail time. And a DUI first offense, for example, is only 2 days. And a DUI second offense is just a few days more. But by the time you get up to a DUI third offense, and this all has to occur within 5 years, and we've talked about the stacking in previous episodes, is that third offense becomes a felony, and you are going to go to the Department of Corrections, and you will spend a significant amount of time there, and in addition to the jail time, you will lose your license for years. Now, a DUI first and a DUI second can fall under a felony category. And when that happens is when somebody is hurt and you were driving under the influence. That is the key there. If nobody is hurt, then usually it's just charged as DUI first. There's a chance that if you've destroyed certain amounts of property, they could up it to a DUI that's a felony level. But what they're really looking for is if you didn't hurt anybody, then DUI first and DUI second are most likely going to slide into the misdemeanor category. A DUI third or a DUI where somebody was hurt is almost certainly going to fall into the felony category.
Okay, let's say I've been drinking and I'm driving and I get in an accident, but the accident's not my fault. Okay, somebody slams into me. What happens there?
If someone slams into you, there's an old attorney in Mississippi. I heard him tell a story about a personal injury case, and he won his case by saying even a drunk man had a right to be in that lane. Now, you will likely get a DUI if there's an accident and the officer smells alcohol and it goes to the station, you blow above the .08. But you may still have a personal injury case against the individual who struck you. And if they struck you and it's clearly their fault, then likely it will not fall into the felony category.
How will a DUI arrest affect my commercial driver's license?
It will wreck your commercial driving career. A DUI first offense on a commercial driver's license means you lose your license for 1 year. There's no ifs, ands, or buts to it. There's no non-adjudication route to skimp away from it. Nothing like that. In fact, used to what we would do is have truck drivers go surrender their driver's license and get a regular driver's license and deal with the 120-day suspension. But no longer can we do that under the current laws of Mississippi. And keep in mind, somebody operating a commercial truck, all they have to blow is a .04. You're not dealing with the .08 to be drunk under the statutes or charged as being impaired under the statutes. So that is something that I always advise commercial truck drivers to keep in mind. And I always advise them to use Taxi Tim's taxi service here locally in the Jackson area. And if they can't do that, then certainly find somebody else to give them a ride, because truck drivers stand to lose a lot more than your average Joe driving to and from work.
Thanks for listening to Ask a Lawyer with attorney Joey Franks at the Franks Law Firm in Ridgeland, Mississippi. Call attorney Franks at 601-773-7777. His website is thefrankslawfirm.com.